by the Honorable Supreme Court in several earlier judgments is not permissible within the four corners of the 96 Act, therefore contrary to statute. This would more or less cover the legal issue according to me, without being specific about sections, but 96 Act. Divorce A above, which possibly may not arise, but I am putting it against myself since the Lordship of the Constitution bench dealing with the subject, your Lordship might as well give the larger picture also. That's the only reason I put it. Whether the Honorable Supreme Court should at all have accepted and adopted the above doctrine as a matter of desirable judicial interpretation and judicial policy. Well, para B.2 tells your Lordships that Honorable Chief Justice Ramanna's formulation would be under this. It would fall within these two issues. Well, as Justice Suryakant, whereas 1042, 3 and 4 are really reasons of his judgment, which is my para B.4. And the first one covers and is subsumed under my two issues. I'm just reassuring my Lord that nothing is really left out. Now, the Lordship should come. I'll read the case law, just come to the conceptual part. This is the most analytical part. C 1 to 16. 16 principles which I have called out. And Lordship will just go slowly here and then we'll read some of the case law later on. May I read this? Summary of principles culled out from existing Indian and foreign jurisprudence, establishing the clear desirability of recognizing and applying the doctrine of group companies and common economic entity in arbitration law. This is my issue B, not my issue A, not the statute. This is issue B. The doctrine constitutes a true and genuine effectuation of the real intent, italics, of parties. Now, actually, these paras use this most liberally of these judgments. Actual paras are given. And there is no reason why the true intent of parties to subject not merely signatories but also related and group entities should not be effectuated. Well, as one batch of cases puts it rightly on the salubrious principle of real intent, true intent. And that is the basic principle. I've given 5 cases, there are more. Second, the doctrine evolved in the context of related entities playing a predominant role both at the negotiation stage, which is at the inception of this, as also in the course of performance of the contract, even though they were not signatories. And I'm asking myself at each stage, what is wrong with this reasoning? What is unjust about this approach? My respectful submission is nothing. It is desirable because it is just, fair, and honest, otherwise logical and correct. My third principle. Well, there is an error. That word not has to be deleted. I'm sorry. Last line of C.2.
Yes.
Even though they were non-signatories, not non-signatory. I hope I'm clear. The not will go on. We'll also correct out. Third principle. Absent such a group company's doctrine, it would allow evasion and avoidance of legitimate collective responsibility arising from the contract and permit injustice. You also see the synergical cumulative impact of all the 16 at the moment reading the numbers. Indeed, to extend the previous point, this is a separate point, it would also facilitate evasion of law through a hyper-technical approach. 5. The group company's doctrine is a reasonable extension of the piercing of the veil doctrine, and some or all of the already established legal tests in corporate law regarding piercing of the veil would, depending on individual facts of individual cases, also arise in favor of the application of the group doctrine. Now, there is an overlap here. For example, take alter ego. Alter ego has been a lordship test to pierce the veil. It would apply here also. Some will not identical, but this is a further natural extension to arbitration law of what is already an established doctrine in corporate law. 6. Jurisdically, the group company's doctrine is also fully justifiable when the requisite and sufficient degree of common ownership and control exists. And there is no reason why such persons, entities should be able to avoid legitimate responsibility on the technical plea of non-signature. Collectively. A seventh principle is one where Your Lordship finds gross injustice is caused. Your Lordship must apply. Sorry, gross injustice. That's the seventh. Then whether I come to implied consent in it. There is no reason, the doctrine can also be justified on the separate juristic basis of implied consent, a well-known concept in the law of contract and arbitration. 9. There is no reason why the group doctrine should not apply if there is a direct relationship between the party, which is a signatory to the arbitration agreement. This I am putting from a judgment to us. Direct commonality of the subject matter, the composite nature of the transaction between the parties, full stop. A composite transaction refers to a transaction which is interlinked in nature. Then was the next principle, and this is juristic. Gary Bond, an outstanding jurist from the continent, German, who is settled in the common law system, has written some very good books. The principle is equally justifiable on both purely consensual theories, he says, agency, assumption, assignment, and non-consensual theories, estoppel, alter ego. And this, Your Lordship, has approved this para Charan from Gary Bond. I believe my Lordship, Charan. It is a vitally useful doctrine to prevent, this is very important, fragmentation of disputes. Kindly note this. And therefore, it is highly desirable for legal and judicial policy. Then, 12. It is of particular relevance contextually in India, a country whose business and commercial structure is more heavily reliant upon traditional forms of family-run businesses, where technical distinctions between signatories and non-signatories would cause grave injustice. Justice Suryakant had a whole paragraph in Cox and Kings read to Your Lordships yesterday on the family business nature in India. Then 13. The doctrine of purposive or teleological interpretation adopted by courts in diverse situations necessitates the application of the group company doctrine to deal with the core issue at hand and prevent injustice arising from technical avoidance tactics based on formal signature or absence thereof. 14. The alter ego doctrine, already known to corporate law, proceeds on the assumption that two or three entities formally, but this formally is wrongly typed, it is ALLY. Formally. That is ostensibly one. Formally distinct are nothing but de facto alter egos of each other and must necessarily be seen holistically in the process of dispensation of justice. Now, when I come to something which will be relevant in the law also, but actually on the desirability, I've dealt with it here. 15 and 16 are related. So we just read 15 and 16. By the 2015 October Amendment to Section 8, by Act 3 of 16, inserting the words any person claiming through or under him, in turn, based upon the reasoning of the 2246th Law Commission, my Lord saw that yesterday in the judgments I have cited the para, the legislative intent to recognize and codify the pre-existing reality of non-signatories, effectively acting through or under signatories, is statutorily recognized so as to do complete justice. Now I come to what I call a red herring of 2-1H. Which also engaged Your Lordships yesterday. The absence of a corresponding amendment to 2-1H at the same time as Section 8 was amended would be irrelevant to the interpretation of the latter. Firstly, the amendment to Section 8 has to be construed on its own terms And both the Law Commission report and the words added to Section 8 in 2015 are crystal clear. Secondly, the effect of those words and the intention reflected in the Law Commission report as adopted by Parliament cannot be nullified or diluted by reports to what might or might not have been done in another provision, namely verse 2H. Thirdly, unless the three-judge bench in Chloro is held by the Honorable Constitutional Bench to be erroneous or unsustainable, it is clear, as important, it is clear that full mind was consciously applied by the Chloro bench to this issue, while contrasting the language of 45 and 8. After contrasting, thereafter the Chloro bench proceeded to read the group doctrine into 45, principally on the basis of the difference in language between 8 and 45. That's paras 94 to 96 of Chloro. Fourthly, if that be so, the subsequent insertion of the same words in 8 by the 15th Amendment must necessarily have the same effect of introducing the group doctrine into 8. Because far from the legislature making any attempt to dilute or overturn Chloro, they were in fact effectuating and endorsing the intent of Chloro Q 45 to another section of the same act, namely 8. Lastly, fifthly, the latter clear intent of both Chloro and of the legislature in enacting 2015 and indeed of the Law Commission cannot in any manner be diluted or nullified by reference to what could be done or might have been done but was not done in respect of 2H. Such an approach to interpretation to whittle down the true intent of Chloro or the Law Commission and indeed of the amendments would be unjust, unsustainable, and untenable. Because these are my 16 principles conceptually, analytically, which is the totality of what I need to call out. They show us A, this is a doctrine based on valid juristic principles, diverse. B, none of these principles are undesirable or need jettisoning by your lordships. I mean, there could be a principle which is most objectionable. None of these are like that. 3, they are mostly backed by existing diverse case law. Almost every principle I have cited the actual para. Therefore, clearly my second issue about the per se desirability and this decides the desirability and the contours. They are the contours. Ultimately, the guidelines are these only. Both must give this doctrine its reasonable full play, unless in my last section, which I am now coming to, your lordship finds the inhibition in the statute. That is. So, something which your lordship has had for almost 2013 was Chloro. So, it was about 10 years, a little more. High courts before that, plus legislation. There has to be reason to dilute it, change it, overthrow it, in whichever form. One is the extreme overthrow theory, one is the total support theory and more expansion, one is the middle theory that supported but with conditions. All three are subsumed in my section C, unless your lordship finds it anathema. The contours, the principles, the boundaries cannot be and should not be whittled down to more than what is in C. They may not be expanded beyond C, I don't know. A future case was common law expands by incremental expansion, slight incremental. But certainly what is existing in these 16 principles, none of them I find so much objectionable in my humble and respectful submission that your lordship's intervention is required. And it is not a stray case, which is now the Chloro progeny. Chloro itself had a mother agreement and a progeny set of agreements. But the Chloro progeny of judgments are many. And today, unless your lordship finds a fundamental problem of principle, the lordship should actually affirm it with these contours. Now, let me deal with the extracts. which cover many numbers, I can read the judgment. I've got the facts of both the judgment also, Mark. Maybe when you Lordship ask me anything specific, I'll do that. But normally, your Lordship may not need to. That's the advantage of putting it down. And that's why we could give it only 9:30, because your Lordship will have, of course, any facts your Lordship want to know, I will certainly go to it anyway.
Dr. Singhvi,
I'm sorry.
while we are at it, you described this leaving out the 2(1)H amendment.
Yes.
Incorporated.
Yes.
And saying that section 8 should be interpreted singly in order to understand what the Law Commission intended. You have described it as a red herring. Why do you say that?
Yes.
Because we are yet to hear the Solicitor General on why
Yes.
either it is left out deliberately or it is,
No, that was the reason behind the thing my learned friend will have access to. I have not found anything.
No, correct. Of
He
course,
will
he
have-
has to say it.
I mean it a different way. My point is not about the reason behind that. My learned friend will enlighten us, and I'd like to enlighten us. The issue in 2(1)H, explain it
Yes,
here,
explain it.
the light of para 15 and 16. Party means a party to an arbitration agreement.
Yes.
Textually, facially. Party here, when read not only with 8, but with the general common law which your Lordship has adumbrated. In appropriate cases, where justice so demands on my 16 principles, will include the group party. So 2(1)H is not anathema. What I am saying in 1516 is only that what your Lordship finds in the full play of section 8, which is the actual text amendment. I'm not saying I'm arguing, I'm saying in the event it is argued. I've not heard Mr. Rai yet, he may not argue it. In the event it is suggested that your Lordship should whittle down the scope and meaning of 8, because 2(H) was not correspondingly amended. That would be a wrong approach to interpretation. That's the only purpose of my saying. So I'm very grateful for the query. So let me summarize. 1. Common law establishes a group doctrine which your Lordships has no particular reason, in my humble submission, to dilute or nullify. Subject to my Lord's decision and committee, that's my issue B. I've given 16 principles. Second, common law to some extent was inserted into 8. I mean, they don't use the word group doctrine, but to some extent, right? And it had a law commission, it had a history before of Chloro, it had 45 and 8, all that stuff your Lordship knows. So second point is that insertion is a recognition by statute of some part, some scope of the group doctrine. Third, question arises that insertion is faulty, incomplete, should be read down by your Lordships, whittled down, or reduced to vanishing point, because the legislation never amended correspondingly to 2(1)H. Answer is no from my side. Fourth, why is it no? It is no because firstly 2(1)H itself is consistent with an expanded meaning of a group party where the case arises. It is not to be limited to signatory. Fifth, the second reason why 2(1)H will not be a hindrance to your Lordships, if it is so argued or put, I don't know which way the direction the arguments will go, would not be a hindrance also because 2(1)H, your Lordship may have amended, may not have. My learned friend will give us the reason why I have not found anything in the Trago Preparatory. It can't affect the direct legislative intent to insert 45 into 8. So that's the fifth point about interpretation. Your Lordship's approach to interpretation should not be, unless compelled to do so, that your Lordship whittles down X by reference to non-amendment of Y.
So once section 8 has come in, you interpret section 8 on its own.
I'm very
understanding and
grateful.
words.
Own plus more fortified by 246, Law Commission and Chloro. Chloro, whether that paragraph I read yesterday, made a clear distinction. It said 45 has this language. 8 does not. Para 59. Sorry, 69. And therefore that led the law commission also, then led to, whatever the reason, they said, look, the code is a point on 45, let's have it in 8 also.
The judgment in chloro should not have a chloroform effect.
That appears to be a potential argument which I was in advance preempting. My lord is absolutely right. A chloroforming effect on 8 because of the non-amendment of 2H would be wrong approach to interpretation. My lord is absolutely right. Chloroforming, deadening, stilling or chilling effect should not be there. I am grateful for this. Now your lordship comes to D. No, they know it. Some of these fellows, quotation the lordship will see, and then these are important. Now, your lordship has a whole development of the law. It is not fellows a one spot of the summer or one fellow splash, one drop in the pond. This is a consistent thing. See the way it is developed, fellows, and your lordship will see what is the objection. So, chloro is fellows intention of parties, the test I said, along with commonality of interest to bind non-signatories. All the paras are given there. Then they also put it on implied or specific consent in para 107. Now, some of these I will read, but at the moment I am only reading the extracts. I have chosen only two, otherwise